I had an excellent question last week about whether or not a tenancy by sufferance ever turns into an adverse possession claim. So let's take a look at the elements in adverse possession and compare them to tenancy at sufferance. So for a tenancy at sufferance, the tenant continues to occupy the property after their leasehold expires, right? So the tenant originally had the legal right to possess. So they had the permission to be on the property initially, but that position expired essentially, and they continue to remain on the property. With adverse possession, you need to have hostile intent, right? And the hostile intent is a bit complicated, right? We said that courts can treat a hostile intent using an objective standard, which means that as long as the other conditions have been met, then there is no need to prove any actual hostile intent, right? But implicit in that is that the adverse possessor has to hold out the property as if they own it. So you could see where that might differ from a tenancy at sufferance, where the tenant is just staying over on their lease. They're leasing, they may hold themselves out or consider themselves out to be a lessor, not an owner. So, to answer the question, the answer is a tenancy at sufferance may turn into adverse possession, but you have to still meet the elements for adverse possession: actual, open, hostile, exclusive, and continuance. So the seminal case on this question is called Glover v. Glover, and it comes out of the Alaska Supreme Court. I'm not going to go into the facts too much because they're actually complex, and we'll spend time trying to understand the transfer of the property. But suffice to say that Glover argued that at some point the holdover, let me rephrase. So at one point, the landowner gave a lease to one of the Glover's ancestors, and the Glovers, the family, continued to stay on the property. And the owners, or the subsequent owners, maintained that Glovers were just holdover tenants, where the Glovers maintained that at some point it had turned into adverse possession. And so the court was looking to answer the question of whether or not a holdover tenant or a tenancy at sufferance can turn into an adverse possession. And here is the most relevant part of the opinion. So the court said non-payment of rent by itself does not establish hostility. So just because a tenant stops paying rent, that's not enough to meet the hostile element of adverse possession. The court also notes that a tenancy at sufferance is a permissive interest and cannot be the basis for adverse possession. What does that mean? Well, like I said in the previous slide, the tenancy at sufferance at one point was permissive, right? And so it turned into a non-permissive estate, but the initial interest was permissive. And so the court says that you can't just use it as a basis for adverse possession. So to prove adverse possession when you have a tenancy at sufferance, any tenant, including a tenant at sufferance, must openly and explicitly disclaim and avow any and all holding under his former landlord. And furthermore, he must unreasonably and steadily assert that he himself is the owner of the true title. The most important part of that quote is must openly and explicitly disclaim and disavow any and all holding under his former landlord. So, in order for a tenant at sufferance to become eligible for adverse possession, they have to disclaim their tenancy. So they need to put the landlord on notice that they are claiming the property as their own and they are holding themselves out as owner of the property. So in the next sentence, the court talks about there must be at least constructive notice to the landlord that this disavowment, this disclaim has occurred. So the landlord must be on notice that the tenant thinks that he owns the property. So if you go down a little bit further, you'll see the court says, I bolded it, our case law makes clear that when a claimant started out occupying land permissively, it is essentially that his new hostile interest in the property must be made clear to the true owner. So what the court is saying is that the hostile intent requirement is not a component of the tenancy at sufferance. And so hostile interest needs to be shown, and the landlord needs to be on notice of this hostile claim. Now, do all courts follow this rule? No. Courts differ. However, this is the majority rule, and it is also reflected in the restatement of property. So in the restatement of property, section 14.7, it talks about the rule, the common law rule. And that is when the holdover tenant is not considered as an adverse possessor just because he's a holdover tenant. And again, it harks back to the point that the holdover tenant entered into possession under the circumstances of the lease. It further brings up the point that if the landlord chooses, the landlord could just reinstate, elect to treat the holdover tenant for another lease term. So they could make the holdover tenant's possession permissive again by just reinstituting or renewing the lease. Well, it's not the case with adverse possession. The restatement makes it clear, just like Glover did, that the only way a holdover tenant can become an adverse possessor is if he clearly repudiates the lease. I just wanted to clear up the difference between these two concepts because honestly, they make for a great bar exam question or exam question is comparing these two. So thank you to your classmate who asked the question.